Today, and we're going to talk about the topic of starting my own company while I am in adjustment of status process. We all know a lot is going on in that there is a lot of layoffs, and also the economy is showing some slowing down a little bit, and priority dates are not moving as fast. So all these things create opportunities, and sometimes those are great opportunities. And we look for them every time to discuss them with you. So we're going to talk about this topic. But before we go into this topic, let me introduce myself. I'm Sam Shihab.
Oh, I'm Brian Burke.
And we're from the law firm of Sam Shihab and Associates. We're going to take a moment and we'll be back to talk to you about the recent update in the H-4 and EAD filing. So with a little bit of good news on the H-4 EAD from the law firm of Wasden Law. He's a friend and an excellent litigator.
Yes, last time I saw him, he was in this room right here talking with us about some litigation, as I recall.
And yeah, I do remember when he came to Columbus, and he made a presentation for us here. And he is struck another success. He's the one that also handled the IT server litigation on H-1B along with his colleagues, and he's able to bring about good news. So let's do the summary on that one, Brian.
Yeah, so I'm sure a lot of people out there are aware that, if you file an H-1B and an H-4 at the same time, for the longest time, go back for about maybe 4 years ago, it would be a pretty good chance that they would approve that H-1B and H-4 at the same time. And if you toss an EAD for the H-4 in that envelope as well, they'd approve all of them at the same time, and people would be happy. You file an H-1B case in premium processing, you get an H-4 and an EAD at a premium processing rate. Good thing, it kept people happy, kept people working, made life better, easier, less anxiety. And then they stopped. They added in a biometrics requirement for H-4 cases, and then they said, oh, this biometrics, this makes things too difficult. We can't approve these H-4s at the same time as these H-1Bs because we've got to get those biometrics in. Suddenly, and it's been getting worse and worse and worse, those H-4s have been taking, months upon months, close, better part of a year to get approved. And then comes this settlement. Basically, USCIS has agreed that, they are going to approve H-4s and their accompanying EADs at the same time as the H-1B. And that includes, giving them the benefit of premium processing. So we're essentially back to the good old times. You file that H-4 and EAD with the H-1B. Great. They're going to be approving the H-4 on the same pace as that H-1B. Additionally, they've only committed to do this for the next 2 years, but I will take that and say that's better than nothing. And one thing we were sort of talking about here in the office, they suspended H-4 biometrics for a while until May of this year, and we were wondering whether that was going to come back. And I think the obvious answer is it doesn't seem very likely, because if they're going to approve those H-4 cases on a timely basis, they can't afford to send people for biometrics. So I think there's a very good chance that we're going to see that H-4 suspension of the biometrics requirement continue and be extended. So executive summary, faster approvals for H-4s and EADs. Great. I love it. I can't help but wonder, Sam, where the other shoe's going to drop for USCIS, where they're going to find the speed and the capacity in order to do this.
If there is a will, there is a way. Seriously.
Because the court has a way, apparently.
Spend less time picking on people unnecessarily, issuing unnecessary RFEs, silly, lengthy RFEs.
Yeah.
When it meets the standard, which is the preponderance of the evidence standard, which is more than 50%. So if your case, according to the law, is 51 acceptable, it should be approved. USCIS for decades have requested a substantially higher standard for approval, which is really almost 80 and 90% of the case has to be.
I consider that to be accurate, 80 or 90%. I always describe preponderance of the evidence. Any less true, and it wouldn't be. Basically, you just have to get yourself 50% of the way there. Yeah,
51?
It's probably true. Probably true.
Yeah. So they drop the standard, they issue less RFEs, they move cases along. The remedy is not very complicated.
They don't even issue that many RFEs on H4s or the associated EADs, though.
Well, they're issuing RFEs on other stuff
This is true.
where resources can be diverted to approving these cases.
This is true. I
Yeah.
will give you that. Other types of cases are still getting hammered with RFPs.
Yeah, absolutely. So, thumbs up for Wasden Law. They've done a great job bringing the settlement to the community. And does that mean if you file a case now in premium processing, Brian, all of them get approved in premium processing?
They should. That's what the
It would appear.
That's
yeah.
what it says.
This is really fresh in the last couple of days, so we will know more about it. But that's fantastic news.
Yeah, we will wait and see what the results are, whether they abide by that for sure.
And I'll take the 2 years.
Yeah.
And then again, last comment on the silly biometrics. Did that get started during the Trump administration?
I believe so. Yes.
So how can they not do biometrics on H-1Bs?
Yeah.
But they do biometric on H4s.
Yeah.
How come they don't do biometrics on F1?
Yeah.
But they do biometrics on H4s, and these H4s were vetted at the council.
Yeah, I know.
All of
Everybody who's been. I mean, unless your fingerprints changed in the last couple of
They
years.
should just cancel it, right?
Yeah.
Just completely cancel it.
I can't see the point of it. Especially more and more, we're seeing that lots of notices saying, "Oh, we're going to reuse your biometrics from a prior case anyway," and there you go.
The biometrics from the State Department.
Yet they're still happy to take the biometrics fee and then waive your biometrics.
That's only $80.
Yeah. Well, that's $80 that's going into somebody's pocket somewhere, and they'd like to have those $80, please, Sam.
Yeah.
There's one way to.
They're not making money on this. This $80, they just need to cancel this
A great way to make $80 is to charge it fine, Sam. Maybe they're not making money on that, but you know how they're making money on it, Sam? If they don't have to do the biometrics at all, and they still get the $80, $85.
Give them the $80, move the case along, man.
Yeah.
For crying out loud, people are, impacted. Well, great news, excellent news. We just gotta, give it a clap here for that good news.
I have a clap button, I'm pretty sure. There we are.
Here we go. All right.
Yeah,
So
I'll turn that off because
perfect.
it'll probably be annoying.
All right.
So.
Now, main course. As we stated, sometime adversity creates opportunity. Challenges create success, right? Invention is created by necessity. So this self-employment opportunity, if you're in adjustment status, is a real solution for those who unfortunately may have been laid off or are in a situation where the employment is shaky and not very solid. I think self-employment is a fantastic opportunity within the same field. So we want to break it down, answer your questions, and hopefully you will learn a thing or two that can be helpful. God forbid you are in the situation in which you have to look at that option. Yeah. So this is all came about in the regulations in which portability was allowed from one company to another company after 180 days of the adjustment filing.
Yeah.
And within the list of options in the regulations, it was mentioned self-employment was an option that's available for you all to be able to do it. And to do it correctly is what we're here talking about.
Yeah.
So let's go into those elements, Brian.
I'm going to just hit the hard basic ones everybody probably knows at this point. But like you said, 180 days of green card pending with your I-140 approved, and you can move on to a same or similar occupation. That's the general portability rule. That applies to, not just moving on to any other company, but moving on to same employment as well. Essentially, they keep you it's more or less the same rules for going to self-employment versus any other employment in a same or similar occupation. But the USCIS policy handbook gives us some sort of, guidance upon what they think about when they think about that. So, when you're looking at self-employment, broadly speaking, there's two things we think about. There's whether your job offer is bona fide, whether it's a true good job offer, and whether or not you're in the same or similar occupation, truly. And, bona fide job offer, they can question whether or not your job offer is good because, it's a company we've never heard of. This is something that's owned by you. You're telling us this is the company you started yourself. How the heck can you sustain yourself that way?
So a bona fide, or I call it bona fide, the way I say it. But for our listeners, they're going to say it's not even English. Yeah. So a bona fide or bona fide job offer, meaning true and real job. That's really means. Would you
Yeah.
agree?
Yeah.
So true and real job. And how can you show it's a true and real job is by showing, what the job is. So there are things like the title of the job, and those are the elements we're going to go into, and we're going to show you how you can do that in the process. We're going to break that down for you, how you can present information to USCIS to show that this job is bona fide. And when you build a company, or let's say create a limited liability company, and then go into self-employment, you're not a lawyer, and these are complicated legal issues. So we're going to give you the highlights on these and help you to kind of guide you on a step-by-step basis. Always, of course, consult with an attorney when you do this. This is probably one of those things you don't want to do this at home alone or try it at home. You want to consult a professional. But without further delay, the second piece is similar job occupation. This is something you guys understand. It's going to have to be, you cannot be in IT and open a company that makes pizza. That's not same or similar job occupation. It's going to have to be, if you are a mechanical engineer, it has to be in the mechanical engineering field. If you're in information technology, it has to be in information technology, and you have to be doing the work in the job description as listed in your labor certification or very similar to it.
Yeah, I mean, I think the challenge there is how do you go from being, an individual contributor at your prior employer to being, it's having your own company, and can you really hit something that's similar to that in that new firm?
The transition, Brian, is significantly mental and the know-how, because a lot of people who are listening to you do not have the know-how or the mental ability to visualize that transition. And that's an attorney that can help you really in these pieces. Now, some people have no problem with that. Some people it just comes natural. If you're coming from a family, descendants of self-employed, everybody's self-employed in the family, it's easy for you to, oh yeah, sure, my dad did it, my uncle did it, my brother has his own company. But if you come from a background that everybody's being a bureaucrat or an employed person, then there is a little bit of a mental.
What does it look like for me to have a business?
Yeah. And that is something a good attorney can help you with.
Yeah. So I mean, it's good that these are the real two things we're talking about, because they really sort of play off one another. I think you start with making sure you have a real, true bona fide business. I've heard people say bona fide, Sam.
Yeah, I did as well.
At any rate, basically establishing, putting together the right kind of business, and usually the job itself will flow from that. So let's talk about, fundamentally for me, a bona fide business, a good, real operating business that the government can have faith in, that can believe, that can offer you good employment. It should look like, the last business you came from. First of all, you can't just say, I'm gonna work for myself, I'm gonna be self-employed. You start an LLC. You pick somebody to manage it. If you have a spouse, for example, that has a EAD, your spouse can manage it for you.
So let's move a little slower here, because there's some important steps that we're talking about.
I'll talk too fast if you let me.
So the first thing is to create the company.
Yeah.
Now, you can be self-employed if you are a one-man show, but in reality, you may end up needing the help of a spouse who has an EAD. So creating a limited liability company is the easiest form. Now, this is not there's a partnership you can create, but really the vehicle that 90% of the people end up creating something called limited liability company, an LLC. And that's easy, quick creation. You need to engage, after you create the limited liability company, you need to talk to an accountant and say, I'm creating a limited liability company, because there is a tax election. Are you going to be electing to be taxed as a corporation or taxed as a partnership? And that's a conversation with an accountant who will understand your vision, what you're expecting in the next year or two, and then they will do an election for you with the IRS. And there's a window of time you have to do that election, and so you gotta just engage a professional, an accountant. If you have an accountant friend, they can help you, or if you have a professional accountant, they can help you. It's not very expensive, but you need to do that. So you've created the company now, the paperwork.
Yeah.
You've created the paperwork.
It's a company on paper, yeah.
Yes. The second thing, obviously, is to if you've made the full move, is to really be on payroll with that company. You have to receive paycheck at a certain time. You cannot not receive paycheck. You cannot just make money like doing work on the side and then they get paid and you just cash that check for groceries. And you have to open its own bank account, separate bank account, the company's bank account. You have to apply for a tax ID number, preferably. And now you have a tax ID, you have a bank account, and then you have to create a payroll.
Yeah.
And then you have to start with some savings, some funds, whether you, I mean, it's
you can contribute money to the company from yourself to fund it, is what you're saying.
You know,
so basically,
throw in $20,000, $30,000, create a loan between you and the company, and you can sign a promissory note. The company can sign an agreement with you.
yeah. The point is, to get yourself on payroll, you have to have some money in the company, and you the individual can put some money into the company that you run, and basically you'll start paying yourself out of that company, and you'll start doing work through that company, and money will come into the company, and you continue paying yourself through the money that comes in, right?
You put the money in the company bank account, and the company distribute regular paychecks for you. Now, there is not a requirement that the payment has to be commensurate with the prior payment, but it has to be commensurate or similar to, I mean, you cannot pay yourself, $12 an hour. That doesn't make sense. Yeah. Let's say if you're making $140,000 or $120,000 in the old company, but you paid yourself $95,000, that's not a big deal. $85,000, that's not a big deal eventually, but it cannot be a bigger gap than that. I would be worried.
Yeah. I mean, we're talking. You're talking about same as similar occupation stuff. But you're right. You have to set up.
That's one of the elements they look at was similar whether the compensation. Now,
it's a good point though. I mean, starting the business and getting those records coming in, it also will. And I'm not gonna talk too much about same or similar occupation yet, but it'll make sure you have those records to show. Yeah. I mean, you're gonna eventually complete a supplement J that says I'm gonna work for my company incorporated, and here's the job I'm gonna do for my company incorporated. I'm gonna pay myself X amount of dollars a year. But if you can produce a W-2 that says, hey, I'm actually down the road, I'm actually getting paid that amount by my own company, all the better.
So, I mean, the mechanics and the formalities are important because you're going through a green card process. And because you're going through a green card process, you want to do all these formalities to make sure that when you're going to the interview, you have this documentation. And it's critical, and that's why I don't want you guys to try this at home. I want you guys to go to a professional that can help guide you through this process. A lot of immigration attorneys do it. We do it. And it's something that is very important that you get help so it's done right, because there's a lot of details to it. It's not rocket science, but there's details to it and it needs to be done right.
Yeah, I mean, what do you think of fleshing it out more, like creating an office space or getting a website for the company?
Well, clearly getting a website is very important. If you're the only person employed, I wouldn't go into an office because there's an expense. But if you go into like a share working, you have an address, something that's very cost effective, not too expensive. That's perfectly. You have professional address. Yeah, that's really nice to do.
In terms of when I'm talking to somebody else, I tend to blow their minds open. I said you can get an office address really, really, really cheap, and it just makes everything a little bit cleaner, a little bit.
Create a little bit of a separation of where the mail is going for business and where the mail is going for your personal life, and that's really important because now you're creating this bright line. You have a bank account, you have an office, you have an address, and then.
The cool part about this, Sam, you're at this point, you have a website, you have a business, you're making a little bit of money, you have payroll, you can employ somebody else too if you're so inclined.
Right.
Which, if you find yourself doing that, suddenly again that's another great factor, for your self-employment. Obviously, you can be employed by your company, but if you have somebody else employed by your company, man, I'd start feeling pretty good about that bona fides of that job offer if you can get somebody else on board, and there you go.
Absolutely. Yeah. And we've had situations where the spouse ended up creating the company, and the H-1B, who is the main beneficiary, ended up being the employee of the company. So that would be two payrolls there, and the spouse is handling the administrative stuff, which is really helpful because now all of a sudden you're not touching anything administrative and you're focusing on work.
Yeah, and that plays into that same or similar occupation. If you're let's say you have a green card I-140 perm as a software developer, and suddenly you're in a position where you're the owner, operator, payroll guy, HR guy, and also the chief software developer of the company, it kind of muddles your same or similar occupation argument. If you have that, and which we have to get to because we keep on talking about it. But if you have somebody else, the point is if you have somebody else to handle the administrative stuff for you, first of all, adds a little bit of heft to the bona fides of your company and keeps your hands clean for the purposes of same or similar occupation.
Right. You look like you will be then focusing only on the work, and that's fantastic. And then the other person does not have to be full time. You could hire somebody part time. If it's your spouse or an employee, you can hire them 10 hours a week. 5 hours, 8 hours a week, they can do the administrative stuff, which is perfectly okay. Put them on hourly payroll for that time. That's perfectly okay.
Yeah.
All right, so let's dive into some other stuff that the USCIS tells us we need to look at.
Yeah, so we're always sitting here, Sam, saying, yes, self-employment, it's okay. But I know there are people out there who say, "Well, I don't believe you. I want to see what the government says about that." And we happen to be talking about this. Always wanting to give people good evidence. And for that, we have the a citation right out of the USCIS policy handbook here, where they really talk about, hey, self-employment is a thing that you can do. And let me fix that real quick. There we go. Properties. Hey, there we are. Okay, so here it is. This is the USCIS policy handbook, and this is their chapter on same or similar occupation. For reference, these are the factors they consider, job duties, job titles, required skills, etc. for same or similar occupation. Sort of things we've already talked about. But here's what they say. Here's their section. Let's see here. A change to here we go. With respect to porting to self-employment, all other eligibility requirements must be satisfied, and essentially
First.
Yeah.
Okay, must be satisfied. So that's what we talked about. The 180 days after adjustment, then same or similar job classification, really. Yeah. So it's a supplement J filing, basically. And that's what they're talking about first, right? That's the first thing.
Bottom line, though, is for me, is that, the government, they are in their own handbook. Sometimes you encounter, if you go to a local USCIS field office, Sam, you find an officer that maybe doesn't know that much about employment immigration. But darn it, this obscure, one step off the road from just a regular supplement J, self-employment supplement J, portability. It's in their handbook. They should know about it. They should feel comfortable with it.
And for everybody knows, this is Chapter 5 of USCIS's handbook.
Yes.
Policy manual.
Volume 7, Chapter 5. We'll definitely put a link in underneath the YouTube when we're done. Perhaps I'll do that. But they have all these nice things they say here about it. Basically, the additional factors that they consider when they're thinking about self-employment. So we'll sort of put those up on the screen here for you and show you what those are. We sort of call them out separately here. There we are. So first, as with all other determinations, other portability determinations, the employment must be in the same or similar occupation classification as the job for which the original petition was filed.
Very straightforward. Nothing to that.
We're going to hold everybody to that same standard.
So with regard to that, just a reminder, what I would recommend as we're closing here on our presentation time, when you create that, if you have an HR in your company, which we recommend you have at least 5 or 10 hours a week, if not full time. Another person does administrative stuff. It doesn't have to be only HR. It could be chief operating officer, whatever you want to call them. They give you a job offer.
Yeah.
Write you a job offer.
That's a great another point of those bona fides.
With regard to this company, we're excited that we've created this company and you are going to be with us. Just for the record, your title is this, your job duties are these, and the skills required are as such.
Now, somebody out there, Sam, is laughing and saying, ha, 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 you're serious? I'm going to have my own company write an offer letter to myself?
Yeah.
And the answer is yes. I mean, it's not about whether it's necessary, it's about whether it's good evidence, Yep. And when as an attorney, when I'm thinking of any case, I'm thinking about building the evidence, trying to get to that preponderance, that 51%, more likely than true, more likely than not true. And the more evidence you have, the more things you can stack up in your favor, it's better.
And you wouldn't want to watch the face of the USCIS officer interviewing you when you hand him this document, because he hasn't seen a lot of these, and it's going to be impressive, in my opinion.
Yeah.
All right, jump into number 2, Brian.
Yes. So second, The adjustment applicant should provide sufficient evidence to confirm that the applicant's business and the job offer are legitimate. If the submitted evidence is insufficient to confirm the legitimacy, or the officer identifies fraud indicators that raise doubts about the legitimacy of the self-employment, the officer may request evidence to show that the self-employment is legitimate.
Okay, now, so what other evidence we're talking about, Ryan?
I mean,
payroll.
Yep.
That letter.
Yep.
Office space.
Website.
Website. But I think for me, most importantly, the contract, the work that you're doing.
Yeah.
So you can do 10-hour work for 20 different companies.
Yeah.
I don't care. As long as you have all these evidence of the work that you've done and evidence of invoicing and payment, all of a sudden you really have an airtight case that cannot be...
Well, yeah. I mean, to be clear, you're speaking of, you're presuming somebody's going to do IT consulting work themselves, right, on their own behalf, perhaps
Yes.
they left behalf. So, I mean, fundamentally, you're going to have contracts then with other companies that want your services. So your company, perhaps it's your spouse / COO or CEO is going to be signing contracts with those clients saying, I'm going to provide so-and-so services to your company. So it's first of all, having those contracts out there. I guess the point is, Sam, is you can't just say, I'm going to work for myself. You have to the government has to believe that your offer of self-employment is viable. You can't just pay yourself out of your savings.
And stay at home, watch TV.
Yeah.
That's not good. So you need to show that you're doing work.
Yeah. And so if you have a company that, has existing contracts, great. I mean, what if you wanted to make a pivot, Sam? What if you wanted to start developing a product of your own? Do you think that's something that's viable?
I would be nervous unless you have amazing funding. But I would be nervous during the green card process to do something too fancy. But let's assume you have amazing funding to it, and you're really doing it, and you have people that really put some serious money in it, and these people are known to be investors in this type of business, then you could. But that's not the common scenario, Brian.
Yeah,
that's not what we see.
I've been asked about that one. I mean, I think you're right. That's a scarier scenario for me, one that I'm more nervous about. But if you can document, that you have interest in your
timesheets and the work, and then the billing against the funds, etc.
Yeah.
There's a method to do that.
But I guess fundamentally, some sort of plan. I mean, that show a path. There's a way that's going to eventually be out there and make money for you on a permanent
there's
basis.
presentations, there's conferences, there's presentations you make. Right.
I think about a business plan
to trade locations and sites and marketing budget for that. If you show all that, that's fine.
Yeah.
But if you don't, then
the consistent thing that we're hitting here is, your business has to be. You have to really kind of expand it and blow it up.
But it doesn't have to be fancy.
Yes.
It can be very simple. It doesn't. You don't have to be ultra successful, as long as you're keeping busy. I mean, let's assume you have an account with Upworks as a developer, and the jobs that you've done over there, you can compile these, and you can show that.
I'm making good money. I'm making good money. I mean, good money is good evidence, is the bottom line.
You're right on the money. Yeah. If you show money coming in, and you're showing, then all of a sudden you're a winner.
I would like to watch them deny that case. So I'm sorry, you've done everything to create a business, and I'm making money through it.
I haven't seen a denial of self-employment that I am aware of.
Yeah, nor
What's number 3, Brian?
Yeah,
coming on the half an hour here.
Last one is third. As with any portability case, USCIS focuses on whether the petition represented the truly intended employment at the time of filing of both the petition and the adjustment application. This means that as of the time of the filing of the petition and at the time of the filing adjustment of status application, if not filed concurrently, the original petitioner must have had the intent to employ the beneficiary, and the beneficiary must have had the intent to undertake the employment upon adjustment.
So I'm not concerned. I don't see a problem in this area, but let's explain it.
Yeah.
So USCIS wants to go back and look at who really applied for your green card and whether they applied for your green card for the purpose of self-employment. It's a paranoid agency. So every time they see something like self-employment, they go, oh, they're playing a game on us. So if your green card was filed by, let's say, a legitimate company that is, a recognized company with 400 employees or 300 employees or 80 employees, and this company's been in business for a long time, you got nothing to worry about.
Yeah.
But if this is created by somebody small,
so fundamentally, you're saying they're paranoid that you're just seeking this employment-based green card so you can start your own business
it's
instead.
a scheme.
Yeah, I don't think anybody goes into the process like that. I don't think anybody goes into the green card process hoping they have to wait 10 years for a green card and then have to wait another 3 years once their case is filed, so they start their own business when they. I think everybody out there wants that green card as soon as possible.
This is written by somebody that does not understand the world.
Yeah.
This paragraph written by somebody at USCIS who has not had enough knowledge of what people applying for a green card go through in real life.
Yeah, I mean,
it's just a figment of their imagination.
Yeah, the number one thing I've learned is, I want my green card as soon as possible. I'm going to join. If I have to stay with this employer forever, I'm perfectly happy to get that. I want my green card. I don't want any pass to it. Yeah. I want them to have approved this green card as soon as I filed the I-45. The only thing I didn't want was for you guys to make me wait, 10 years to make this necessary.
Be that as it may, this is a requirement that they may look into the history of your green card application. They're welcome to look into the history of the green card. You got nothing to hide. So without further delay, we are going to come back to answer all your questions. All right, so this is the part of the presentation when we answer your questions, and we do the best we can to try to give you some guidance. 3 things to remember. We don't know anything about your case more than the 3 half sentences that we read, and therefore you should not be relying on the discussion to make important decisions about your case. So you always should consult with a competent attorney before you make a decision on your immigration case. And obviously, while some of you guys are our clients, and some of you are not, both are welcome. But by virtue of this YouTube exchange, there is not an attorney-client relationship established. Without further delay, I have a question from
AK Srivastava.
All right.
So, hi Sam/Brian. Hi Sam/Brian. I filed I-45 last year and got EAD/AP. I went for vacation outside of USA and used my AP while entering the USA. I have 2 questions. Number 1, my H-1B is expiring in August this year. I'm with the same employer who filed my I-140/I-45. If I file my H-1B extension with the same employer, will I go back to H-1B status again and get a new I-94?
Well, this guy has written the question so well.
Yeah.
I'm so impressed.
I think this guy's read the memo on this, or the letter on this.
Well, I'm sure he's done his research without asking me. People don't ask you the first question here without
doing a little bit of looking. Yeah.
Yeah. So, great question, well stated, well presented, and the answer is absolutely yes.
Yeah.
You will get back on H-1B per the memo from a guy.
2000. I think it's a memo. Basically, a memo from I think it's like 2004. Basically,
okay.
And there's a memo out there where USCIS says if you leave your employer, you leave the United States in valid H-1B status, and then you enter the United States again on advanced parole with your pending adjustment. After you come back in, you are a parolee. But if you file to extend your H-1B status, they should allow you back on H-1B status.
Question number 2.
Yes. My AP is also expiring in August this year and plan to file I-131 renewals. Will this impact H-1B extension over extension time period? No interaction. There shouldn't be any interaction with an I-131 and the H-1B.
So it will not impact the H-1B extension time period whatsoever.
Yeah.
And that's an excellent question with regards to the advanced parole, and these are great questions, but what boggles my mind is how complicated they made this immigration law such that people have to ask those questions. I mean, those things have to be so simple and straightforward.
I think I don't know. I think it's how mean. I think it's more about how mean the system has been. Maybe that's what you're saying. It's basically I'm worried that if I do X, if I don't tap my head and touch my belly, every morning, that the immigration service is going to snuff out my immigration status. It's creates a paranoid, and I don't blame anybody for being concerned.
Yeah, 100%. Yeah, I honestly think the problem with our system is that it is a patchwork. It's really, right now, quite frankly, USCIS have not been mean. USCIS has been very nice and very accommodating. And this lawsuit settlement that we've talked about, the combined, this is, by the way, is an agency that is interested in helping. This is not an agency that lost or settled because they're going to lose. They may lose, they may win, I don't know. But this is an agency that looked at this and said, there's enough people upset about what's going on here. We need to do something about it, and we want to fix it. So whether they fix it by policy or they fix it by settlement, whatever, this is an agency that is wanting to do the right thing. In the prior administration, when we had the IT serve litigation and we had to go and sue for some ridiculous rules that denied people H-1Bs after they spent 10 years here and they refused to even look at prior approvals when they were reviewing new cases and start handing out denials, they went all the way to a court ruling.
Yeah.
They fought this all the way until the judge decided. This is an agency here that's saying, you know what, we're not wasting time on this. We got better things to do. Let's go ahead and fix it.
That's the scary part, though, Sam. All it takes is a change in administration, and suddenly everything gets turned upside down.
Always been the case in immigration law.
Yeah.
Always been the case in immigration. But those are great questions. Let's take the next one question from Mr. Van.
So, priority date December 2013. Applied for I-45 in 2021. Both EB2 and EB3 approved. I-140s, I presume. Recently, my EB2 I-140 is changed to correspondence received and USCIS is reviewing. I am planning to switch employer and use EAD. Is there a follow-up here? Yes. Will there be any problem? So, that's a,
So there's some things missing here that we need to clarify.
Yeah, for sure. But bottom line for me is I'm seeing somebody has, an I-140, the EB2 I-140, and their status message online says USCIS has received some sort of correspondence. So I guess what I would say, Sam, is the online tracking from USCIS is oftentimes not accurate. Or it could be accurate. I don't know. I guess what we don't know is what that correspondence is. It could be that somebody has withdrawn an I-140. It could be that you sent it in the AR-11 on your green card.
So let's look at the basics.
Sure.
The basics is number one. Has there been 180 days since the filing of the adjustment of status?
Yeah.
So that's the first question that you should ask yourself. Yes or no? Of course, it's not here. It would read that
I-45 filed in 2021, so it has to be.
In both EB2 and EB3.
Yeah.
So that's 180 days past.
Yeah.
So check that.
Yeah.
Now, is it same or is it similar job classification?
Yeah.
You're switching to a new employer? Is it same or similar job classification?
Yeah. That's it.
And if the answer is yes, okay, you got nothing to worry about.
Yeah.
There's nothing to worry about whatsoever. I mean, these are the facts. This is the law. Obviously, you're changing employer. I always would say this is probably one of the most delicate area of the green card process. And bring your attorney in, bring an attorney in that you trust, have them look at this for you. If the attorney that you're working with is the company's attorney, you're 100% entitled to get yourself your own counsel outside to advise you on the details and to get an expert eye on it for you. But for me, whether they change the message or not, that's not really the question.
You're right. It's a bit of a red herring. You're right. As long as you've met the requirements for portability, it doesn't matter what the I-140 status message online says.
And get help. I mean, and get somebody to help you out. And it shouldn't cost you too much money for somebody to say, hey, I looked at your adjustment, your I-140, I looked at the dates, I looked at the job description, I looked at the new company, they're going to sign the supplement J, you've talked to them, go down a full checklist, check yes, 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 okay, I don't care what the message says. USCIS can change the message every 5 days, every 5 minutes. Who cares?
Doesn't matter. You've met the portability requirements. Yeah, there you go. Yeah.
And that's my opinion.
Yeah, there's a little bit follow up here. FYI, 45 cases still in status remaining pending for primary and derivative applicants, and there you go, as they should. It doesn't matter if that I-140 message changes. They should. Your employer, I would point out, Sam, that employer can withdraw an I-140. They cannot withdraw your I-485.
Right, and if you cross the 180-day magic line, there's no impact on you.
Yeah, just gotta find another job.
Yeah.
Another question here from Raul Roy. My spouse started using her AOS EAD. She also has a valid H4 until February. What status is she currently in? How does USCIS track her status? An excellent question. As I-9 is only kept with the employer, if I understand it right. And I'm going to work from the back. You do understand it, right? I guess there's E-Verify as well that also may be used. But how does USCIS know? How does the individual USCIS officer that's going to review the case know, Sam?
Well, that's not really from you.
Yeah, exactly.
Because they're going to ask you.
Yeah, they're not going to know. Is the bottom line for me.
Yeah. By the way, how do they know is a question I've been asked for as long as I've been practicing immigration law. How do they know? They don't know half the time. More than half the time. They don't know until they are ready to approve or review a case. Then they will ask you certain questions under oath.
Yeah, that's a great point.
And then they will collect information under oath, under the penalty of perjury, and you're supposed to answer correctly, and then they'll make a decision.
Yeah. A very common thing, not incredibly common, but a somewhat common thing is you will see RFEs from USCIS. If they think these issues are important, they will say, "Hey, tell us where you worked, for X period of time, and tell us what your employment authorization was, and document your status during that time."
What status is she currently in, Brian?
Well, USCIS doesn't know it, but when you use that adjustment of status EAD, it's like oil and water versus an H4, and you abandon your H4 status if you use an EAD that's not associated with your H4.
That doesn't answer the question. The question, what status is he in?
No status. No status.
Okay, and there's nothing wrong with that.
Correct.
And abandoning an H4 is nothing wrong with it either. So we use big words.
It's a choice you make, yeah.
We use big words in the law here and scare people. Oh, abandon, oh my goodness.
Yeah, I'm sorry, I didn't mean to scare.
End of the world. So calm down, Brian. I'm going to explain.
You abandon it, but you put yourself in a period of authorized stay by the Attorney General.
I'm going to get to that here in a second. So she is in an authorized stay under the law because of her pending adjustment status. Agree?
Period of stay authorized by the Attorney General. But yes, I do agree.
Yeah. And the other piece is that the H4 is no longer applicable because she's made that choice. She made that turn in the intersection. In the law, we say they abandon it, but it's not something bad because when you abandon something, it's bad.
You leave it behind for something just as good that protects you just as well.
Yes. Yeah. Did we answer everyone here?
I think we did. I think I started by doing them in backwards order, but I'm in a mood today apparently.
Yeah. Well, no, I would have taken in backward order as well.
Yeah. Here we are. Here's a question from Momo Lee. Is it possible to transfer H-1B with pending I-485 and EAD if spouse of H-1B visa holder who has a EAD starts an LLC? How hard is it to prove employee relationship and ability to pay?
So there's two things going on here. He's asking how is it possible to transfer H-1B with a pending 485 and EAD if spouse of H-1B visa holder who has a green card EAD starts an LLC. So he wants to start to do an H-1B to that LLC.
I think that's best of both worlds. It's start the company, do portability to the company, as well as do an H-1B transfer to that new company.
Yeah. So how hard is it to prove employer-employee relationship vis-a-vis the H-1B petition, obviously, and the ability to pay? So there is the I-485 and the portability of the I-485 employment. We've talked about that in the first half of the hour. Yeah. We don't have to repeat that, but I think we've answered it. That should be straightforward based on the parameters we've outlined earlier today. Yeah. With regard to the H-1B, Brian.
The H-1B, that is in theory possible. I don't foresee it being approved by USCIS. I mean, first of all, the employer-employee relationship standard is very low right now. It is hire, fire, pay, otherwise control, and basically it's hire, fire, and pay. If you can hire and if you can establish, hire, fire, and pay somebody for the H-1B rules right now, you've established the employer-employee relationship and right to control. However, do you think that they're going to approve?
No, I don't.
Yeah.
So, with regard to the H4 to the 485 and self-employment, that's specifically mentioned in the regulations. Underlined. Yeah. Okay, and also talks about how to accomplish that. With regard to H-1B, what's specifically mentioned is that H-1B is not a self-employment visa.
Yeah.
Now, I know it's not your company and it's your spouse company. I understand that. But
that's when the RFE comes in to say, tell us about this business, and they say, that's that, yeah.
But the issue here is it sounds very much like self-employment. Now, if your wife company is a company that has 400 employees, and you'll be just another employee, and your wife is just the CFO or the CEO of the company, and there's HR.
Well, sure, yeah.
Then that's okay. But in the scenario that you're presenting, it would seem to me that what you're doing is simply creating a company for the green card portability and to do something like a self-employment path, which is perfectly okay. But you want to tack on an H-1B on top of it, and it doesn't work.
Yeah, I would say even though it's a really, really nice time to be filing H-1Bs, they're approving a lot. I think that all the bona fide stuff we talked about for the purposes of portability, where they might be laughable to some people. The person who'd be laughing in that scenario is USCIS in the H-1B scenario. It's
yeah. So unfortunately, you practically speaking, the H-1B. It more than likely will not happen.
Yeah.
All right, so let's take the next one.
Yes. From Animesh Tiwari. Hello, do we need to inform or update somewhere if laid off from H-1B and want to switch to AOS status? I mean, like after the 60-day grace period of H-1B.
So the way I'm reading this, Brian, is that there's somebody who has a pending adjustment of status and on H-1B, and that person moved on. Beyond the company to EAD, using his EAD, working for somebody else or self-employment, whatever. But he's no longer on H-1B. That's the scenario I'm reading it. Do you read it differently?
I'm reading it a little bit differently because I'm reading a little bit of legalese into it. To activate the 60-day grace period, you have to be terminated, right? You have to have a cessation of employment. So I'm presuming somebody's been actually laid off.
So termination of employment, Brian.
Is that, technically not the grace period. It's a cessation of employment.
Yeah. So you don't have to be terminated, right?
Yeah. As soon as I say that, I read I picture it in my head. We've had long talks about this. Yeah. So the bottom line is, somebody is no longer working on H-1B status. You'd agree with that, right?
Yeah. Correct.
Yeah.
Yes.
So is there anybody you have to notify, Sam?
No.
Yeah.
You don't have to notify anyone. This is really a connection to the prior question. How does USCIS know? USCIS would know when they're looking at your adjustment.
They ask.
It could be an RFE. There's a supplement J, right? When you move out, so they know indirectly by your supplement J whether you're self-employed or whether you are working for another employer. You've given them notice. Now, so supplement J, as we've talked about, is not necessary to file it immediately, right? This is the conclusion that everybody's heading towards in the interpretation of the regulations and US
policy. Yeah, it's in their instructions for the form, I believe. Yeah.
But eventually, you're going to do that, and eventually, when they're making a decision on your case, they're going to find out.
I would elaborate and say, you don't have to tell somebody you're taking advantage of the benefits of having pending adjustment of status, because you always have the benefits of a pending adjustment of status. As soon as you get that receipt notice, you have the benefit of that allows you to stay in the United States while your green card case is pending. There's nobody to notify. The government already knows you have that benefit because they issued you a receipt notice for your green card.
But the benefit is conditioned upon stepping out of the H-1B. And his question is, how do they know? So the benefit you have, which is an EAD...
The benefit is not conditioned on stepping out. I mean, I guess the benefit doesn't matter until you're stepping out of the H-1B.
Well, I'll phrase it differently.
Okay.
The benefit consequence is not being on H-1B, which is the employment authorization document. The consequence of using the benefit is we're not going to use the word abandoning, is a bad word. it's stepping
I'm
out of the
make you
H-1B.
afraid to talk to us. You can't say anything without me going, no.
So stepping out of the H-1B.
Yeah.
So his question is, how do they know?
Here's how they might know, even though they wouldn't really track it back to your adjustment status case. If your employer is assuming somebody has been laid off on H-1B status, your employer should be notifying USCIS and revoking your H-1B petition. So that's one way, in theory, they could know that your H-1B has been withdrawn. However, the likelihood of the person who receives the withdrawal request on your H-1B notifying the officer that has your adjustment of status case and putting that in your file, very slim chances, based upon my knowledge of this agency.
Yeah. Nobody looks at anything unless there's a case to adjudicate.
Yeah. It is very possible for USCIS to do research in their own records and figure these things out, but generally speaking, unless they have a great reason to, they won't.
SS, which is my signature, is asking.
Sam, are you seating this thing? Are you sitting there on the
I just sent that
phone?
question, yes. Yeah. SS. Go ahead, Brian.
I have approved EB1B, 180 days to complete post I-45 filing, and received EAD. Can I work 2 jobs, one in similar and one in non-similar category?
Well, what a wonderful question. You can work in any job you want. The non-similar is not going to lead to a green card.
Yeah.
The similar, and I'm assuming you're moving to either another job or you're taking on a job that's non-similar. I'm not sure what scenario.
Well, people have asked me about the scenario. What if I want to do some volunteer work on the side or something like,
Well, he's not volunteering. He's making money.
Well,
but let's say he's doing day trading. So let's assume he's in IT. And now
your
he
assumption's
wants
better than my assumption, Sam, because yours is the more likely one. Yeah.
Well, because he's not going to volunteer. Trust me, there's no volunteer in that question.
Okay.
Which is fine.
Yeah.
Which is a good question. But volunteering is a good discussion item. But this gentleman looks like he's doing something that's completely different. Let's say he's in IT. Now he's continuing to be in IT. It's 1B, so it's probably this is intercompany transferee.
No, that's EB1C is I think that's EB1C. I think you're outstanding. Is that
Could be a researcher?
Outstanding professors and researchers.
Could be a researcher.
Yeah. Well, bottom line.
So he wants to do day trading.
Yeah.
20 hours.
Yeah.
No problem.
Yeah. That EAD. The bottom line is that EAD doesn't have any limits. The big thing is you have to be. You file that I-45 intending to take the job that's offered to you on a permanent basis. As long as you're intending to actually work that job full time upon getting a green card.
Perfect. Yeah. Hopefully we answered S's questions.
Yeah.
Sai.
Any possibilities for EB2 dates become current for May 2012? That's first of all, regarding the visa bulletin, it is. I guess we're kind of soft in the visa bulletin right now, Sam. It's very
no movement in February.
Slow to move, and we're anticipating seeing the most likely time you're going to see movement again soon is April. We agreed.
That's what we think.
At the end of the next quarter. So if we're talking about May of 2012, and I presume you're talking about India EB2. That's quite a bit ways off still. It's about 6 or 7. What is that? 8 months.
Yeah. So what's the dates for filing for India EB2 now? So it's May
1st of May 2012. India EB2. Yeah. Well, Charles Oppenheim, the guy who used to manage the visa bulletin for the Department of State until he retired about a year ago, said, the visa bulletin is supposed to be a 8 to 10 month, I think it was, outlook for the final action dates. So I guess I can't help but be a little bit optimistic on that front. But, then retrogression happens. The visa bulletin used to have much more forward-looking dates, and now they jump backwards. But
it remains a forward look.
Yeah.
It remains a forward look. So the fact that May 2012 is in the dates for filing, it tells me that that date will close by October.
Yeah.
That's the theory. So the window at the beginning of the year is big, and then it gets smaller, and then the September or the October visa bulletin should get to that date. That's the vision.
Yeah.
So is it possible? Yes. Beyond that, we really have no idea.
I guess the bottom it is. It's not a guarantee, of course, but basically, based upon the data they have right now, we think May 2012 is in the foreseeable future of being current. We think it's worth we think if somebody has a filing date of May 2012, it's worth to file your case now, because we think by the time we're ready to approve that, your date will actually be current.
Yeah.
So cross our fingers for you, Si.
And Sai has confirmed the next that he is from
India.
Yeah. All right, anonymous.
So, my son is protected with CSPA after he turns 21. Fantastic.
That's a question. That's a statement of fact.
Yes.
He's giving it to you. He's not asking.
Yep.
Just to make sure.
Yeah. Were you thinking out?
Before, I don't want to go.
I'm easily distracted today, and I could get stuck in the CSPA analysis. So I'm saying fantastic. It's good. I'm taking for granted
when
that
he turns 21, do I have to notify you as CIS, or do I have to take any kind of action to let USS know that my son is turning 21 and is protected?
Do you know what this is, Sam? This is another how do they know question. And the answer is,
it's a good how do they know
Yeah,
question.
and the answer is if they're concerned, they will ask. Granted, I can't remember though. I don't CSPA, RFE. I don't think I've ever seen such a thing.
No, but I can see it coming up. For example, although USCIS has been very good with Child Status Protection Act analysis, I've not seen them make silly errors.
Yeah.
So you will see it with an EAD renewal. You may see it if they're on so just so you understand, the Child Status Protection Act does not extend to protecting the H4 if the child is under H4. The H4 runs out at the age of 21. But the EAD and the advanced parole will continue to renew because the adjustment continues to be pending. So there could be question on that in the EAD renewal, but we really haven't seen that.
Yeah, I mean, I know we have plenty of clients out there with kids who have transitioned past 21, and I just can't remember. I mean, I'm scratching my brain here, thinking I can't think if I've ever been asked saying, "Hey, you're not entitled to this because you've reach the age of 20. They're aware that H4. We've seen RFEs on occasion saying, "Hey, you only get H4, for example, until 21." And the answer is, "We know, okay."
Yeah. If they issue an RFE on this, it's because they don't believe they're protected in the Child Status.
I mean, I guess it is possible. We're taking what Anonymous here says for granted, but it's possible for them to say,
"We disagree."
Yeah.
If
they say you disagree, that's
and that's why I said at the beginning it's a fact.
Yeah.
Because we're not analyzing whether it is. So Anonymous is comfortable with that.
Yeah.
He believes his child is protected.
Yeah.
Now, I'm assuming that he's taking the advice of a professional, or at least one, and he is beyond any doubt, that his son or his child is protected under the Child Status Protection Act. Yeah. And if it's not, then you ought to do it, Anonymous.
So sort of a follow-up, does using I-45J to transfer job affect my son's CSPA eligibility?
That's a great question. The transferring job, no.
The portability, using the 180-day portability after your I-140 has been pending 180 days portability revision, INA is 204J it is, perfectly fine. But if you say we're to try to take advantage of a transfer underlying basis, you'd be changing your I-140, and if you change your I-140, you could, in theory, change your child's CSPA calculations.
Right, but that's not the question. Yeah.
That's not the question.
He's doing. He is changing employment.
Well, yes. So
that's not the second part. Is not. I don't want to confuse him.
But I don't want to confuse anybody else out there because if you
100%. You're right.
Using I-45J,
the transfer job.
Yeah, I-45J has two boxes you can check on page 1 of the form. One of them is, hey, I want to take advantage of an I-140, and the other one is I want to take advantage of portability. And
that's right.
If you check that I-140 box, just okay, I don't think that the government ever catch on to that, but if you change the I-140 as the basis of your adjustment, it could change your CSPA calculations, which we won't talk about.
So everybody clear. So vis-a-vis this question, changing job, it does not. However, be aware that other actions such as transfer underlying basis, when you're switching I-140s, may affect the child.
That's the point I would make. This is different than transfer underlying basis, and you can really mess with your kids' CSPA protection there.
Yes.
Here we are. SS. I lost initial job, but I-45 is pending over 6 months. I have a job offer from new employer in the non-similar category. However, they need a green card.
I lost initial job. Sorry to hear that. 45 pending over 6 months. I have a job offer from. Well, I mean, I mean, that's what we're talking about, self-employment. My God.
I would say talk to so self-employment is something that might work for this person, but I'd say talk to an attorney about, non-similar category. If you read the USCIS policy memo on similar occupations, I'm going to talk too high about SOC job codes, and they say, hey, anything in the 15s is probably same or similar to your existing 15, 1132 or 1252 now software developer application. So I think I guess SS knows his life better than I do, or his or her life better than I do. So if it's, you're going to be a baker and you're previously working as a database administrator, state that with confidence, but that's a problem. You need to find a job. The bottom line is portability is only allowed for same or similar occupation. If USCIS asks, you need to produce a same or similar job offer.
Self-employment is your answer.
Yeah.
And don't be afraid, because like I said at the beginning, sometimes these challenges create opportunities, and these opportunities can make a wonderful change in your life. I know nobody wants to be self-employed sometime, and they want life easy, but you may not have the choice.
Well, see, Sam, I'm gonna say a mea culpa here, because SS put this statement here, and we turned it into a question, and he or she actually has an actual question here. Can I work a non-similar job, keeping the existing job offer in the same or in a similar category till I get the green card?
Well, that's a great question for a 7 o'clock time.
Oh, geez, we're past 7 o'clock.
Yeah, which is wonderful. We're happy to answer questions. So this one requires a little bit of digging into, because whether or not there is an intent to move out of this job by the employer or the employee brings into question whether or not the job is bona fide.
Yeah.
And that up to the green card approval.
Yeah.
And that's a concern if USCIS finds out, meaning that the employer is just keeping you so you can get your green card, really doesn't want you, or you're staying just because you want to get the green card and you don't want to stay longer. Either scenario creates a concern into this third prong that USCIS says in any case you have to be able to show that the job was bona fide, that the employment opportunity was bona fide all the way until the green card approval.
Yeah.
So that's my answer.
Yeah, I think that's a fair answer. Essentially, you're saying if you've been laid off from a job, the government can question whether or not that job offer, that there's a temporary job, before you get a green card, and it's your green card permanent job. If they laid you off before you got a green card, they can raise the question, we don't think you have a job offer available to you upon getting a green card, right?
Or they say, I want to lay you off, I want to wait until you get the green card, and then I want to lay you off. That is a concern. If USCIS finds out, that's basically what they're keeping you just for the green card. That's not what the process is about. You're getting a green card because you have a job. You're not having a job to get a green card. Yeah. And it's kind of a distinction without it. Sometimes like you're being too picky. No, USCIS look at those things seriously. Let's take one more, Brian.
Okay. I realize this is a sort of a part 3 follow-up. Uh-huh. So does the I-140 being withdrawn by my company affect my son's CSPA status?
Beyond 180 days, no.
Yeah, I guess. Yeah, the company cannot withdraw the I-140 beyond 180 days.
Yeah, beyond 180 days, no impact.
Yeah.
So we'll take one more bona fide question, speaking of the word bona fide.
Yeah.
And then we'll conclude today.
So here we are. Does spouse being fired on I-45 EAD affect I-45 approval?
Absolutely not.
Yeah. They don't.
Sorry about her getting fired. But the good news is, no, it doesn't affect it. She's a derivative to you. The spouse. No, when I say she, he or she is derivative to you, and therefore, it's not a problem.
Yeah. Usually, when I talk to people about interviews to prepare them, as they say, I say, spouse, you are here to look your best, but fundamentally, your two requirements are: did you maintain your immigration status through the green card filing, and are you their spouse? If you meet those requirements, you're going to get a green card too. Yes. It's really most of the burden is on the primary.
And no questionable background.
Yeah.
No.
There's 1,001 little bonus butts on that. But
if you answer yes or no, the appropriate question to 1,500 questions on the adjustment application.
Yeah, for sure. Yeah.
Well, thank you guys for listening to us. Hopefully, it was helpful discussion today. and don't know what to bring next week, send us suggestions. Happy to answer those questions. And watch out for those short videos we'll be releasing next week and the week after, per many requests from you guys.